Welcome back. I'm attorney Thomas Burton. I'm an estate planning and asset protection attorney here in Wisconsin. And today's question comes from a viewer, and it's a question that has to do with estate planning, real estate, and limited liability companies. So I'll summarize it briefly for you. This person called me up and explained that they own an LLC. They're members in an LLC with their parents. The son has a 50% interest and the parents have a 50% interest. This son also has a sister and they're the only two children of the parents. And the question to me was, what happens to that 50% in the LLC? And I should mention the LLC owns rental real estate, multiple rental real estate properties, which is a great way to own and manage your real estate portfolio through an LLC. But the question posed to me was, what happens if the parents were to pass away? And I'm not sure if they have an estate plan or not, but if they passed away, what happened to their 50% interest in the LLC? Does it go all to the son, or is his sister involved? And so I sketched it out here. Basically, we've got the parents, two children, son, daughter. We've got the real estate LLC. The son is a 50% member. He's in business with the parents, and the parents are a 50% member. So what happens at death if the parents were to both pass away? So the answer here is, first, I would look to the LLC operating agreement. You can include transfer on death provisions in the LLC operating agreement, sometimes what we call like a last man or woman standing provision, and it can say right in it what happens if one of the members is passed away. Sometimes the company has an option to purchase back the interest. Other times it'll say it goes to the surviving member, or it could say a discount value on the interest, that it can be repurchased by the company at a discount, things like that. So if you have an LLC and you work with an attorney, this is a great place to put transfer on death provisions in the operating agreement, especially if some of the members don't have an estate plan in place. Now, my preferred method would be to pass this LLC interest through a trust. The great thing about an LLC is you can put real estate into the LLC, which is real property, but the LLC turns it, that membership interest in the LLC under the law is tangible personal property, meaning when we set up a trust, we can execute a one-page assignment and assign that LLC into the trust. We don't have to file any deeds or do anything like that. The deeds are already held inside the LLC. We assign the LLC to the trust, and the trust can dictate what happens to the LLC interest upon death very easily, avoiding probate on the entire value of the assets in the LLC. So if you have an LLC, I love when people walk in and they have a business in an LLC, and I can tell them how easily we can assign this interest to their trust and avoid probate on the entire value of the business. They like this very much, and it's an additional bonus reason for holding businesses inside of an LLC and then using a trust as the vehicle to pass them at your death. So the parents in this situation could put together a trust, and they could say either they want what they want to happen, if they want the daughter to receive an interest in the LLC, or they might say, since this is the business with the other son, we want the son to get the interest in the LLC. We're going to give the daughter some cash or some other asset instead to equalize it out. However they want to handle their estate, that's up to them. Now, then he asked me what happens in the absence of anything. So let's say there's nothing in the operating agreement, they don't have a will or trust. Then under the law, I believe the daughter, if the parents pass away with no estate plan, the daughter would be an heir and would get half of their membership interest in the LLC. So if the parents, if she's the natural, they're the only two children, they would be the next heirs if both parents are gone. And the daughter would receive the parents' she'd receive half of their 50% interest in the LLC, right? So she'd end up with 25% membership interest in the LLC, and the son would have 75%. In essence, she would become a minority member of the LLC, and it depends on what the operating agreement says about voting interest, but under default LLC rules, usually majority interest rules, so 51% could take any action under the LLC. So again, this, in the absence of any estate planning documents, it would get to the son and the daughter, but it would have to go through probate. Probate court process time and fees would be assessed on the value of that LLC interest passing to the children. So this could add up if there's significant real estate in the LLC. It would be better to avoid this, in my opinion. Of course, I would want to know more about the situation, the goals of the parents and the clients to be sure, but that's my general thought on how to handle it. So it would still get to the son and the daughter, but the daughter would become a member of the LLC. So if these folks' daughter is not interested in running the real estate business after they're gone, it might be better to not leave her an interest in the real estate business and leave her with money instead, or use life insurance. You could pay her through life insurance to try to equalize the estate. There's a variety of options. But if this situation happened, the son could buy out his sister from the real estate interest. He could buy out the estate for the value of the 25% interest in the LLC at the time of death of the parent. So that would be the other option. But it can get messier this way, establishing value, figuring out what it is, all that stuff, and you have to go through probate to do it. So it would be better, I think, for the parents to lay out how they want it handled, and that will help the son and the daughter upon their death, just so there's no family disagreement. Because often families get along, but when something's unclear, there can be misunderstanding after someone passes, and then it can lead to hurt feelings for those who are left behind. So, great illustration about using an LLC for real estate, specifically rental real estate, and how LLCs can help you easily pass on that property to the next generation with bypassing probate by pairing an LLC with a trust. So great question. Thank you for submitting. Thanks for watching. If this has been helpful to you, consider giving it a like and subscribing to our channel so that more people can find and benefit from this content as well. Thanks for watching, and we'll see you next time.